Hey guys, so we have Ilona Anderson here. She is an amazing attorney. She does wage violation law. She does employment discrimination cases and kind of like, I guess, workers' rights.
Yes. Workers'
rights is probably a broad umbrella. Sains Anderson is the name of the firm. You guys are in Aventura. Aventura. Beautiful city. My guy Grant Cardone is there.
He is?
He is there.
Okay. I've never seen him live. You know, I've read his book, The 10X Rule.
Oh, okay. I'm wearing the 10X stuff right here. Boom.
Yeah. He's such a powerhouse.
He's great. Because you talked about growing in the pandemic. Yeah. So cool. So I
wish we grew 10X during the pandemic.
You can. It's not too late. We're still in the pandemic. We're going to be in the pandemic for 10 years.
Probably.
Oh, no. The government's going to kill me for saying that. All right. So we have Ilona Anderson, originally from
Russia.
Ruski. We got a Ruski with us. I love it. Cool. And so tell us about you, your firm, where you went to school. You got an amazing history about how you came to America, if you want to share that.
Sure. So I came to the United States when I was 16 years old. I came on my own without my parents. I came on a high school exchange.
Cool.
I was living in Russia. It was shortly after the breakup of the Soviet Union, and the United States government has passed what was called Freedom Support Act, which created various exchange programs to foster friendships between the Russia and the other former Soviet Union republics and the United States. So my mom happened to hear an ad on the radio, and she encouraged me to apply, and I went through this rigorous process of application. And I was lucky enough to be selected to come to the United States. And it was a scholarship program, so we didn't get to choose where we went. They matched us with host families, and wherever they could find a good fit, that's where they sent us. Okay. So they found a family for me in Alaska, and I ended up going from Moscow to Anchorage, Alaska.
Did Sarah Palin see you coming across over there?
It was nobody had any idea who she was back when I was living.
Thank God, there, the good old days. That's an amazing story. It's almost like a movie from the 80s, if you think about it, about like foreign exchange, coming to America. Well, yeah. There was a funny movie back then. I forget what it was called, but it was like these guys, the Soviet Union or Russia was trying to recreate American culture in Russia, and they had these two guys come over. They thought they were in an American city, but things seemed off. I don't know. I'll find it. I'll send it to you. It was
doesn't ring a bell, but sounds.
It was really cheesy 80s movie. It was good. Yeah. So you ended up going to law school. So
I graduated from the university. Well, I did my exchange year in Alaska. Before going back to Russia, I got admitted to the University of Alaska because I wanted to keep my options open. I fell in love with the United States. I wanted to be able to come back.
Okay.
And I did come back and attend the University of Alaska, and then I moved to Miami for law school, and I attended St. Thomas University.
Okay, Miami.
Yes.
Nice. I like it. I went to FIU Law in Miami.
Okay.
We're obviously rivals, but everybody in Miami's family. So Miami's a great city. Awesome. So cool. So you went to law school in Miami, and then you went to work somewhere, or you opened your practice right away?
No, first I was working at Ackerman.
At Ackerman, wow.
Yes. Then I actually did go back to Russia for a little bit, and I worked at KPMG there.
Is that an international firm or a Russian firm?
Well, no, KPMG is the Big Four consulting firm, the tax firm.
Oh, like I'm thinking of KGB. I'm
KGB,
like, oh no.
No, I did not work with. Well, okay. I cannot say that. I'd have to kill you.
Oh no, don't kill me. Oh man.
So we'll just say KPMG, not KGB.
Okay, perfect.
So I was working at their in their legal. They're a consulting firm that does taxes and audits and accounting and things like that. But I worked in their legal department doing mergers and acquisitions, due diligence projects, things like that.
Okay.
Then I came back to the U.S. I worked at another law firm that focused on asbestos and tobacco litigation.
Wow. Okay.
And I didn't really work a lot on asbestos and tobacco cases myself, but I handled med mal, products liability, a lot of miscellaneous cases, had my first employment case in federal court,
was
which was very interesting.
Work? You're doing defense work or plaintiff
side?
Work? Okay.
Plaintiff side.
Okay,
yeah,
cool.
Yeah, I really enjoy being on the plaintiff side. So working at that firm for 3 years really prepared me for going out on my own, which is ultimately what I wanted to do.
Okay.
So when I was 5 months pregnant with my first child, I decided, now's the time. I was working 6 days a week. Saturdays were mandatory at the firm.
Wow.
There was not much flexibility, and I didn't want to have to choose between my child and my career. Wow. So I decided, if I'm going to start something of my own, then the time to do it is now while, the baby's still in the belly. Wow. Because it'll only be harder. And so that kind of propelled me onto that entrepreneurial path. And then a few months later, I met the person who ultimately became my law partner. And we've been now working together since 2012. I'm partnered officially since 2014.
10 years. Okay, wow.
10 years working together, 8 years as partners.
Wow. That's I've been married 8 years. A lot of people don't realize that a business partnership is a marriage. And
I call him my work husband.
Work husband, yeah. And it is a marriage, and it's there are breakups, but it's a beautiful thing when people can stick together long term in a work environment, because it's not just so single focused. Like at my firm, it's just me. I'm the only partner.
Yeah.
I have some great people on my team, but I make the decisions unilaterally. We're going to go left. We're going to go right. And with a partner, you have to kind of balance that out, right? Is that, you guys?
You do, but we have a very harmonious partnership. We're very complementary in many ways. He has strengths, and then I have strength in other areas. And
do you want to tell everybody his strengths and his weaknesses on here? Or no? You might watch it. We don't.
In that case, he has no weaknesses.
He has none. Okay.
But early on, we decided, we need to kind of make a decision in terms of who is accountable for what at the law firm, right?
Okay.
And so we decided one of us should manage litigation, the legal work, and then the other one should manage the business aspects of the firm.
Okay.
And so I went with the business aspects, and then he went with the litigation. And
he got the short end of that stick. I personally hate litigation, handling it myself. It's contentious, it's argumentative over what might be a minor detail now could be a big detail in a trial. So you have to really, push for your favorite set of facts in a case. And that part of litigation can be tough always. You bring it home, stuff like that.
It can be. It's exciting, but it's also, you spend your days fighting with people all day long.
All day long.
Whereas, when you focus in more on the business building aspects of the law firm, it's more, you grow in something, you're building something. So it's more collaborative.
Yeah. I just, it's funny you mention it. So I do mostly what you do, which is working on the business side of the law firm. And my litigator, Chris Casper, he's a litigator. He's going to war every day. And there's a, big insurance company that rhymes with, Fate Farm or something like that, or whatever. And I was talking with the lawyers there, and we were, he's in contentious litigation with this lawyer over something. And I pick up the phone, sweet talk the attorney. Hey, how you doing? What's going on? Listen, why are we fighting over this? Let's just get this settled. I'll throw out a number. You can talk to your client, get a number back to me. Let's get this settled. So that's what I did. And he's been litigating for 3 years, and I picked up the phone because we needed to get some movement on some cases to make a client happy or something. And he's like, damn it, Abe. He's like, I come in like the hero at the end of the 3 years or whatever it is, So I personally...
But also sometimes it takes that fresh perspective. Sometimes we get so much in the weeds. We see it sometimes, with the attorneys that work with us. Mm-hmm. They may be working on the case and they're focusing... on the trees and not seeing... Getting
discovery done, this and that, depositions.
As opposed to, you take an outside look and you take a look at the file and you're like, wait a second, we're losing money here and this case is ripe for settlement. And
that's what I
more
said.
Work is not going to result in a better outcome for the client or for us.
Right.
We need to do something.
Exactly. So I'm going to take a guess. You're the more organized person of the two. Would you describe yourself as that without getting in trouble with your partner?
So I'm more, he is organized. He's very organized as well. We're both very systematized, but I would say he tends to be a visionary and a big picture person. And I tend to be more of an implementer for things.
Okay.
There's overlap. there's
Right.
overlap in both. But, he comes in with big ideas and he's ready to go. And then I'm, oftentimes trying to figure out, okay, how do we structure this, and who do we need to hire, and how do we need to advertise, and how do we, the operational aspects of it.
Right.
Yeah.
That's awesome. So I am going through the process right now in my office. We have many attorneys, many employees, and I'm going through the process of, I want a written procedure, like a training manual on how do you send out a demand letter? How do you how do you file a complaint? And I want it, bullet point, step by step. So when we hire someone, as we continue to grow, we hire someone, can give them the manuals for those job duties and say, this is your job, figure it out. It's all right here. We'll train you a couple days, but this is it. And it's really hard. Have you guys done something like that in your office?
We are in the process of doing it. I mean, we have been doing it for years, and we're in the process of improving it.
Okay.
Because
like updating it, right? Because things have changed.
But you know what? I feel like we're every year, maybe even every 6 months, I feel like we're reinventing things, because systems we've created, nothing stagnates.
Right.
And we decide, there's a better way of doing things. We could be doing this differently. And so sometimes it's just updating. Sometimes it's just scrapping, throwing it in the garbage and starting over.
Yeah.
It depends. But we did realize that we were spending a lot of time retraining people as new people came in. And it was taking my partner's time, my time, other employees' time. So we started, we started documenting everything on paper, but also when we train an employee, we started recording that on video.
Okay.
So we do a Zoom training video session, for example, and then that video is created and it goes into a training library. So then when a new employee comes for that position, they watch the video first, and then if they still have questions, they come to us with questions.
And they can always go back to it as well. They're like,
and they can always reference it,
right?
as well, because it's one. I mean, you have to explain things over and over again. Oftentimes, I mean, that's just the reality of it.
Oh yeah.
I mean, we know these things. We know things about our business because we run our businesses. But when a new person comes in, everything is new and it's overwhelming. It's a lot of information.
Yeah.
So whether it's having an employment manual that's written, or videos, or ideally both, it really improves the efficiency of the law firm and the training process. And when it was just me and my law partner and our assistant, it wasn't a big deal. When we hired a couple new other people, it wasn't a big deal. But when we started hiring more, and then maybe firing, or people leaving and then hiring, we realized, we're spending a lot of time on this. And from the very beginning of our partnership, we've been very systematized. We've read E-Myth, we've attended Tony Robbins' Business Mastery.
Oh, okay.
So, even though both of us lawyers and were involved in litigation, and I was involved too up until about last year, I was still handling casework. We try to approach it as a business and systematize it as much as possible, take out as much busy work as possible, make sure that we have workflows for everything, make sure we have templates for everything. We don't want people wasting their time creating documents from scratch or reinventing the wheel when that could have been, So we want people using their best judgment and their training of their attorneys, their legal minds, to do what attorney is supposed to do, as opposed to
typing.
Yeah.
I had a lawyer. It annoyed the hell out of me. We have these motions to compel, which is a standard form. You just change the date. Like discovery was sent to opposing counsel on such and such date. They have 30 days to respond. They didn't respond. And it's just a motion to compel. And this guy would customize every single motion to compel. And we file like 10 of these a day. Paralegals type it up, lawyer reviews it, gets sent out. And this guy would customize each one with a new sentence somewhere. And I don't understand why. I said, is it the same sentence every time? And he's like, yeah, I want it always to have the same sentence, but sometimes not. I'm like, can we create a template for it? He was literally typing it every single time. It was the most obnoxious thing. And as far as workflow goes, the paralegal would send it to him. He would look at it, make some changes, send it back. But why? If you could teach the paralegal, when it's this thing, I want this sentence in there. When it's this thing, I want this sentence.
Or when you use software, I mean, if you create a template that then auto populates various fields, so, whether it's case style, whether it's defendant's name, law firm,
right.
Even, we would have templates for an unpaid wages complaint. We would have templates for unpaid wages with retaliation. We would have templates with unpaid wages and, Florida cause of action, or discrimination federal court, discrimination state court, just, templates for everything that are saved on our practice management system. And then you can create a basic document with just a few clicks of a button. And then what you add is, you add the facts, you add the case law that's unique to the case, but you don't have to worry about adding parties' names or checking the spelling, because if there's an issue with grammar, then you go back to the template and you fix it on the template.
Yeah, I love templates in the law office. I hate when there's a case and a lawyer, hey, what was that case we had 5 years ago with this guy and that guy? I need that complaint. And I'm like, dude, you should have just templated it. Now we're sitting here wondering what the guy's name was from 5 years ago. So I love templates. What kind of practice management software do you guys use?
We use MyCase.
MyCase. Is that 100% cloud-based?
It's 100% cloud-based.
Okay.
So we use it. It's a comprehensive solution. So we use it for case management, case documents, calendar, tasks, workflows, templates, client portal, payments, billing, all of that.
Oh, wow. Do you guys ever bill your clients, or it's all contingency work at your firm?
So on discrimination cases, so our firm is about half of our cases are unpaid wages cases. That's minimum wage and overtime under the FLSA, the Fair Labor Standards Act.
Okay.
So we're in federal court and we don't bill clients up front. It's not exactly contingency because there's a fee shifting provision, meaning that the employers, if we prevail, the employer is responsible for our attorney's fees. But then,
when you say prevail, is that $1? You just have to collect $1 or?
Yes.
Okay.
Prevailing, yes.
Okay.
But I see where you're going with this, right? Because and the judges are very cautious about that because they still look for proportionality. If you get a judgment for $1, well, if you get any judgment or even settlement in an FLSA case, it has to be approved by the court. You have to submit it to the court for approval.
Oh, okay.
And yes, even though technically, your fees are what they are, right? If you billed $50,000 in fees and the client only got $1, they're still the prevailing party. But the judges in that case will reduce your fees because they look at proportionality. They will.
Okay, interesting.
So,
okay, and so that's in a federal context or state or both?
That's strictly federal.
Okay.
And then for discrimination cases, we file in federal or in state court. It depends. Strategically, whatever makes sense.
Okay.
Or depending on which statute we're filing under, whether there is a state counterpart or there isn't.
Okay.
So the discrimination cases, which includes harassment, that's a form of discrimination. Retaliation, that's a form of discrimination. And discrimination is when somebody has adverse employment action taken against them because they belong to a protected category, whether it's age, gender, disability, national origin, pregnancy, etc., or if they engaged in protected conduct. Maybe they complained about their unpaid wages, maybe they filed a workers' compensation claim, etc. So those cases we take purely on a contingency fee basis. So,
do you guys charge? Do you guys charge for consult? Or no?
If it's a case that we're interested in taking on a contingency fee basis, then we don't.
Okay.
If somebody comes in and they need us to draft a contract, or they need advice on a severance agreement, maybe they have been sued, maybe they're an employer, they have been sued and they're trying to figure out what their strategy should be.
Okay.
That's more of a strategy session with an attorney and we do charge for those.
Okay.
But when somebody comes in with an unpaid wages case or a discrimination case that we know we more than likely or not, we're interested in taking, and we would want to take it on a contingency, then we don't charge.
Okay. Okay, cool. So all right. Let me think for a second. So you guys, let's talk about some cases. Do you want to talk about some cases you guys had at the firm? And
I'd be happy to.
Okay, cool. So tell me about your biggest case that you guys had in terms of a verdict.
Okay. So our biggest case was not only our biggest case, but to our knowledge, and I could be wrong, but we did the research and it seems I'm correct. Back in 2019, it was the largest religious discrimination case in the country.
Okay.
The largest discrimination jury verdict in the country.
In Florida, this happened, but it was countrywide. The case was in Florida.
The case was in Florida.
Okay.
The case was in Florida. It was actually a pretty highly publicized case. We handled it with co-counsel, Mark Broomer, an excellent injury attorney.
Okay.
But he generated the case, but he came to us because he's not an employment lawyer, and he's heard good things about us, I guess. And, we decided to work together on that case. So that case was on behalf of a dishwasher who was working for a hotel in Miami, a hotel owned by the Hilton Hotels chain. And because she was Haitian and she belonged to a religion that prohibited her from working on Sundays.
Okay.
So she worked at the hotel for a number of years, always asked for Sundays off as an accommodation. The accommodation was granted, no problem. Then a new manager comes in and says, I want you working Sundays. And she says, well, wait, I've always been accommodated. He says, no, I want you working Sundays. Mm-hmm. Okay, then she goes and gets a letter from her priest explaining the nature of the religion and why, pursuant to the religion, she should not be working Sundays. The manager disregards and says, no, I want you working Sundays. She says, well, how about I have somebody else cover for me? I have this person who's willing to cover for me on Sunday, and then I have this person who's willing to cover for me next Sunday, and then this person who can cover for me, the following Sunday. Mm-hmm. And the manager says, I want you. Now, remember, she was a dishwasher, so she was not an irreplaceable employee.
Anybody could wash dishes.
She did not have any kind of special skills. So it didn't matter. There was no reason why it should have been her. And so the standard for religious discrimination cases is that the employer has to provide a reasonable accommodation as long as it does not cause undue burden on the employer.
Okay.
And that really became our winning argument. Maybe with another type of employee, the defendant, the employer, might have been able to successfully make an argument that they needed that specific employee, and therefore not having that employee on a Sunday would have caused undue burden. But with her, that argument failed. With her, that argument entirely failed. And so we weren't able to settle the case. We didn't receive any meaningful offers. We went through the summary judgment stage and prevailed at that stage and went all the way to trial. Okay. Tried it in Miami in federal court and she did get her wages back, which was, a relatively small amount.
When you say wages back, she lost her job?
She lost her job.
Okay. And so what did they pay her for the time of when they terminated her till...
So the standard.
How does that work?
So the standard is until you find another job, as long as you're making an effort to mitigate your damages. Because the employee cannot just in perpetuity claim damages if they're just sitting on the couch, been watching Netflix and not looking for a job, right?
Right.
So generally it's about a year, unless you find a job sooner. Or if you find a job, but the job pays, let's say, considerably less, then you can still get the difference.
Okay.
It's a fluid standard, but that's about what the standard is. You have to make an effort to mitigate damages, and then you get paid, generally for about a year. And so she got her wages, but then the jury also awarded punitive damages in the amount of $21 million.
So punitive damages, punishing damages to punish the Hilton for their bad behavior.
Exactly. And, as you know, as an injury lawyer, because punitive damages are often awarded in injury cases, right? Products liability.
Not often enough.
So punitive damages, you really don't look at how much money the employee is making and what the employee needs, because this is not considered a reward for the employee. This is considered punishment for the employer. Okay. And because we had a very wealthy employer, the jury determined that 21 million was the amount that
21's my lucky number.
Is it?
Yeah.
21 or 21 million?
21. I guess I should be thinking a little bigger. So back wages plus 21 million. Are you allowed? I know there's that was the verdict, so you're allowed to talk about that. Are you allowed to talk about? There was caps and stuff like that. Are you allowed to talk about that, or?
Yeah, we ultimately there are caps on damages that come into play, and we ultimately settled out of court for a confidential amount, so that I cannot discuss.
Okay. So the jury liked this lady, felt bad for what happened, and wanted to send a message to the Hilton. Don't do this again.
Yeah. And we had a fantastic client, which can make all the difference when you're in the courtroom. She was credible, honest, likable,
Went
hardworking.
to church every Sunday.
Yeah. Her entire family was there. I think we had, a big chunk of the Haitian community and her congregation actually showing up there in the courtroom to support her. So,
plot twist: the trial was on Sunday.
Courts are closed on Sunday.
Lucky her. So that's a great case, and that's a great story. Tell me, how did she come about finding your firm? Because I'll be honest with you, I don't see enough. When I drive down I-95 or the Turnpike, I see car accident, ? Call me, or car accident, call me. I never see a single billboard that says, did your boss screw you over somehow? Call us. How do you guys, how did you come across this client? And then also, when are you going to start doing billboards like this? Because I think that's a great idea. But how did these clients find you guys? Is it a lot of word of mouth?
So the majority of our cases come from referrals.
Okay.
Whether it's referrals from our satisfied clients, whether it's referrals from other attorneys.
Awesome attorneys who refer you
usually
some
it's other
cases.
attorneys such as yourselves. Yes. Yeah. So this case also came from another attorney. Actually, an attorney that we did not have a prior relationship with.
Okay. Wow.
But the client went to him because he is active in the Haitian community.
Okay.
With charity work, etc. So she came to him, and then he went on a quest to find an employment lawyer who would work the case with him. And I don't remember how many lawyers he talked to. I know it was at least one, because I know who that lawyer is, who declined the case.
That lawyer kicking themselves right now? Like, oh no.
That lawyer declined the case. There might have been more than one lawyer that rejected the case. And then he came to us because, really somebody recommended us because of our reputation. Employment law is a very small community. There are not that many employment lawyers on the plaintiff side. There's a lot of defense lawyers.
Okay.
But there's, I don't want to say handful, it's more than a handful, but there are not that many plaintiff side employment lawyers.
Okay.
So over the years, we've been able to establish a very good reputation through the results that we get for our clients. Mm-hmm. So another attorney, I actually might have been the attorney who declined the case. He was opposing counsel on a couple of cases, and he said, hey, you should really go to Science and Anderson. Maybe they will take it. And we did, and we were able to get this result together with our co-counsel.
Because I found you guys through another attorney that I said, hey, I'm getting all these calls. I don't know what to do with them. And he recommended me to you guys, which is how I found you. But
reputation is everything.
There you go. It's interesting because there's not a lot. Is it a lot of competition in this industry that you're in this employee rights type of industry in Florida, at least?
I don't like focusing on the concept of competition. Mm-hmm. To me, it's kind of foreign, because I believe that there's plenty of work for everybody.
Yeah. Right.
So we're not necessarily trying to compete with other lawyers. We're trying to provide the best service we can. Mm-hmm. And we wish them the same success that we're experiencing and more, because, unfortunately, there is a lot of violations happening in South Florida, and there's a lot of people that need help. So it's not a matter of competing with another law firm. It's a matter of just finding ways to tap into that market and provide solutions, and let people know that they have rights, and encourage them to stand up for themselves, because a lot of people are not, they brush it off and they move on to the next job, and they don't take any action. And because for whatever reason, maybe somebody told them it's not worth it, maybe somebody told them it's expensive, and they don't realize these cases are handled on a contingency fee basis. There's a lot of misconceptions too. A lot of people think that once you sue your employer, you'll never be able to get another job because all the other employers will know about it, and that's largely a myth. Mm-hmm. So there's a lot of myths circulating out there that cause people not to enforce their rights. Yeah.
Awesome. So what type of client is most common? What kind of issue is most common in your office? If somebody's watching this and they're like, oh man, she sounds like an amazing attorney. When would somebody need your services? Just give us a scenario of something that comes up often with a certain type of worker or something like that. Is it restaurants? Is it what is it?
I wouldn't say it's a particular type of industry. It's more of a particular type of client.
Okay.
And particular type of client, if we're talking about unpaid wages, there's a lot of undocumented workers that come to us that need help, and probably a lot more that don't come to us because they're afraid, right? They're afraid because of their status. But the law protects all employees, whether they're documented or undocumented, and that's another issue that we're trying to educate people on. It's the employer's responsibility, right? To check the paperwork, so if the employer hires somebody who is undocumented, it does not absolve them of the responsibility to pay them the minimum wage, to pay them overtime, to, protect them from discrimination and harassment, and et cetera. So a lot of living in South Florida, given that there's a lot of immigrants here, it is a very common issue that we deal with, unpaid. And another reason why this is so common, specifically with undocumented workers, is because their employers often know that they're not going to take that step to defend their rights. So they're
scared.
Yeah, they're scared. So they think, and they feel like, okay, you're lucky enough to have a job. You don't have papers. You're lucky enough to have a job. Like, would you really expecting me to pay you time and a half for any hour over 40? You're like, no, work 80 hours and I'm going to pay you, $300 and that's it. Shut up. Don't complain. You have a job. You should be lucky.
That happens a lot. I've known people who were undocumented that were a chef in a kitchen. 12-hour days every day, 7 days a week sometimes. I've known people that
chefs are sometimes exempt.
Oh, chefs are exempt. Okay.
Chef,
these are waiters as well.
Yeah, waiters are not exempt.
Stuff like that.
Cooks are not exempt, but chefs are, because it's considered a managerial position to actually manage people.
I'm not cool. I only know one chef. I don't know. These guys were not chefs. These were more like cooks, I guess. I guess the chef is the guy who prepares this is the type of menu we're going to have and stuff like that. Like the head chef, is that?
Yeah.
It's more like a senior.
And the reason they're exempt is because oftentimes they have managerial responsibilities and they can make decisions to hire and fire two or more people.
I was talking more about cooks, like the guy in the kitchen cooking all the food, sweating to death. It's hot in the kitchen. Dishwashers. I mean, a lot of these guys, we represented a guy who was in a car accident and was scared. He ran. He didn't want the police to come. He thought he was going to get arrested. He was a victim in the accident. He was stopped at a red light doing nothing, and he was rear-ended, and he ran. And we've had a lot of clients like that over the years where they run. They don't want to pursue an injury case after a car accident. They don't want to pursue it because they think that the other person or the insurance company is going to go after them somehow. And, they have real significant injuries, but they just don't want to do anything, or they're worried about high medical bills. So that's I guess we share some similar demographics in some clients in that regards, where they're scared about their documentation status and the future, right?
Right.
Have you ever had employers retaliate against someone for bringing forth a claim of discrimination and stuff like that? Yeah.
All the time. And they're protected from, employees are protected from retaliation. So what often happens is, if it's a discrimination case, the prerequisite to filing a lawsuit in court is to file a charge of discrimination with the EEOC. And oftentimes when somebody files a charge of discrimination with the EEOC, then the employer fires them in retaliation. But that only makes the case stronger. But the kinds of retaliation that we've been running into a lot lately, and we have a large amount of those cases, is, and that's something that a lot of people don't think about, because, I think majority of people are familiar with race discrimination, right? Pregnancy discrimination, disability discrimination, those are kind of well-known claims. But workers' compensation retaliation, oftentimes when somebody files a workers' compensation claim, the employer just decides to get rid of them. And they're protected under Florida law. They're not protected under federal law, but there's a Florida statute that protects them from retaliation. So then they're able to get damages in the form of unpaid wages and even emotional distress in some situations. So we do handle quite a bit of those cases, and oftentimes employees are not aware of that. If they get injured on the job, they go to a workers' comp attorney, right? The workers' comp attorney does the injury. That's workers' comp is not an employment law claim. That's an injury claim, right? So it's handled by a workers' comp attorney in front of a special court, and they get their compensation for their medical bills, maybe for the, time they miss work, et cetera. And then, if they get terminated a short period after that, oftentimes, they don't take any action. But if we can prove that they were terminated because they filed or even just attempted to file a valid claim for workers' compensation, then they're protected under Florida law, and we can bring an employment law claim on their behalf.
Okay. So I had a guy who he was injured on the job. And so I was representing him because he was rear-ended by somebody, and he had a work comp claim for because he was on the clock. And he told me, I got to drop my case. I got to walk away. The boss has been giving me a tough time, and I'm worried about losing my job if I move forward. The boss sat me down and told me I'll get fired, but they didn't actually do anything about it. How does an employee handle that situation? What would you suggest if someone was in a situation where maybe they didn't fire them, maybe they didn't take anything away yet, it's just dirty looks, and what's going to happen if you keep going forward with this? What do you suggest, or is that a
so similar to how things are with personal injury, right? You have to look at damages. It's not enough for you to prove that there was negligence, that there was, causation, negligence, etc. You have to look at damages. In some cases, are just not worth pursuing unless you have damages. Okay. So in this case, you really start accruing damages after you've been terminated.
Okay.
So, yes, if you're getting dirty looks, well, under Florida, if it's in the workers' compensation context, right? Okay. The wording is adverse employment action. So it could be termination, it could be demotion. Dirty looks are really not enough. Okay. Dirty looks sometimes, could be an element of discrimination if we're talking about somebody in a protected category such as race, gender, disability, etc. Okay. But even then, you still have to prove that they've been damaged. You still have to prove that they, suffered as a result of that type of treatment. And so I wouldn't say we never take cases when there hasn't been termination, but most of the time the case becomes ripe for filing when there has been termination.
When they're terminated, okay. Yeah, because I remember there was a bunch of guys who were landscapers, I think, and they didn't want to proceed with anything. And they said, my boss said he's going to fire us if we keep going, and I like getting paid. And these guys, I remember, were they had a criminal history. So it's tough for them to get a job. And so they didn't want to risk it. And they had a legitimate claim. They were stopped. They got rear-ended, whatever. Yeah.
Yeah, so. I mean, it does become cost-benefit analysis for certain employees, right?
Right. Yeah, if I'm 3 weeks behind on my rent, I can't afford to lose my job right now. So, okay.
But oftentimes, unfortunately, employers know that, and, they take advantage.
Yeah.
They know, if that boss knew that his guys had a criminal record, and he knows he can continue mistreating them, and they're not going to do anything about it because they can't get a job anywhere.
Right. Not to get too political here, but I'm sure you've been getting a bunch of phone calls, maybe not so much recently with the Supreme Court ruling on the mandate. Yeah. It was kind of like a blanket category mandate, and there should have been some exemptions, I guess. What are you guys doing with all of those phone calls that you get? Hey, I'm going to get terminated if I don't get a mandated vaccine, something like this. Yeah. Do you guys have any input on that?
I wish we could help those people more.
Yeah.
Honestly, I wish we could help those people more. The legal landscape is such that they don't have a lot of protections. Employers have a lot of leeway in mandating vaccines. I think it's reckless to empower employers to make those medical decisions on behalf of the employees. I think it's a very slippery slope, but unfortunately, legally speaking, there's some interesting cases happening, that are outside of employment realm. We'll see how they play out. But, the OSHA enforcement for after the Supreme Court ruling, OSHA essentially said we're not going to, we're dropping the enforcement altogether, right?
Okay.
Except for federal workers and except for medical workers, right? But, here in Florida, we still have a lot of medical workers, right, who for one reason or another don't want to get the vaccine.
Right.
And employers, even if there's no federal mandate, a lot of employers are still mandating, taking that decision to mandate the vaccine for their employees. And so even with the act that DeSantis passed, 2 months ago,
what did he pass?
Well, he passed legislation that basically it does not prevent mandates. And I think the way it was structured in Florida is that they didn't want to have a preemption issue with federal law, right? They didn't want it to be in direct conflict. If Biden's executive order says, we're going to have this mandate, you get into some constitutional issues when Florida says no. Mandates will be illegal in Florida.
Yeah, does state law trump federal law? Does federal law, which one takes precedence?
Right, and this is really the issue that was argued in front of the Supreme Court, right, a few weeks ago. But the legislation in Florida says that although employers can still mandate vaccines, they have to accept the religious exemption. They have to accept the medical exemption. They have to accept pregnancy exemption for somebody who is pregnant or is planning to become pregnant.
Okay.
And they have to accept natural immunity if you can show proof of antibodies. Which just blows my mind that the federal law did not have an exemption for natural immunity, considering that millions of people have had it and recovered from it and are immune.
There was a senator who asked someone who does research for Johns Hopkins University, and he's like, how much money has the government spent on researching vaccines and masks and this and that? And they go, how much money? And it's like trillions of dollars, right? Like billions of dollars. Is how much money have you guys spent on studying natural immunity, antibodies after you've had the cold or whatever it's called, COVID? And sorry. That was a slip of the tongue. That was not a political statement. COVID, and he goes $0. And so, so you're saying now that DeSantis passed a law that allows for more exemptions than there were.
Allows for more exemptions,
federal.
yeah.
Okay.
So I think Floridians are definitely in a better position than people in most states, and especially New York and California, for example.
California.
But it's still not enough because, I mean, my opinion, right? Because mandates are still allowed, and there's no private cause of action for violations of the law. There's only fines.
Oh,
so if somebody's employer still requires the employee to get vaccinated and does not accept their exemption, then they can't sue pursuant to that law. They can complain and the employer will be fined. But, I heard through the grapevine, I haven't verified it, that, FPL, for example, is telling its employees that, you need to get vaccinated. We're not going to accept your exemptions and we'll pay the fine. We'll just pay the fine.
Oh, wow.
And then,
Okay.
But
if they don't terminate anybody from it, can they be sued? Like by the employer with your office or something? Like if they don't get terminated, there's no damages?
Well, if they don't get terminated, then they have their job, right? So there's nothing to sue over, right? So if they, we're exploring some possible causes of action, maybe under the Florida Private Whistleblower Act. There's no precedent for that, but under the Florida Private Whistleblower Act, an employee can sue for retaliation if they have been terminated as a result of refusing to participate in an employer's illegal activity or legal conduct.
Oh, okay.
So, an argument can be made. I don't know if we'll be successful in the courts or not, but an argument can be made that when an employee requests an exemption, a valid exemption, and the employer fails to accept it, the employer is violating the law. And so, if the employee still refuses to get vaccinated and they get fired, then there could be potential claim under Florida Private Whistleblowers Act.
Okay.
There also could be potential, discrimination claim if somebody claims a medical exemption and that they can prove that the vaccine would is more likely than not to cause some sort of, serious damage to their health, or maybe they have a pre-existing condition that would prevent them from either getting vaccinated or is more likely, to cause further damage, then potentially there could also be claim for disability discrimination, things like that.
Okay.
So, we're staying tuned in to how the law develops.
Okay.
We're also always open to helping people obtain their exemptions.
Okay.
They can either come to us, or we can refer them to another lawyer, to another law firm that specializes in that and does an excellent job.
Okay.
But yeah, we wish we could do more to help workers.
Cool. Yeah, my friend works at the hospital here at Boca Regional, and they're all like, "Oh, you're a hero. You're this. You're that. You're so amazing." During the pandemic, and now it's like, was it like December 1st or something like that, where they said you had to have the vaccine by December 1st, and then they didn't do anything, and then December 5th they said, all right, we're taking it all away, never mind. And or maybe it was January 1st, January. Okay.
Yeah.
And then a few days after they were required to have it or get fired, they didn't do anything for a few days. Then they said, all right, never mind, just kidding. And so but he didn't get it. But anyways, this isn't a podcast about vaccine mandates. But last question, I just want, because you brought up an interesting point. Can I, as an employer, require my staff to get the flu vaccine or any vaccine? Just not related to COVID, because you kind of made a comment that you could. Is that true?
Yeah, generally, yes.
Oh, okay.
Generally, yes. If you can show that it's for the benefit of the firm.
Okay, interesting.
For the benefit of others.
Okay,
yeah.
interesting.
Yeah. I mean, I'm not a.
That's not legal advice for anybody watching this. Okay.
I'm not a vaccine scholar, but on these issues.
Okay.
But it's my understanding that employers have a lot of leeway in doing that.
Okay.
Now, I mean,
that might be weird in an office, like in a law office setting, requiring someone to have a particular vaccine for whatever. I got you. We're with you on that.
Yeah, but I think you have to look at situation on a case-by-case basis and look at the prevailing science. And I'm not a scientist, but I think it's pretty clear right now that the vaccine does not prevent infection and transmission, the COVID vaccine. And if the vaccine does not prevent infection and transmission, then how can you make that greater good argument? You're not protecting anybody else. People that are, vaccinated are getting COVID at the same rate, if not higher, than people that have not been vaccinated. So it's a personal decision. If people want to get vaccinated, fine. This is not a decision, discussion whether this should or not. But if people want to exercise, their medical autonomy over whatever decisions they want to make about their body, and it doesn't have negative impact on anybody else, then I just don't see any justification for the mandates. I don't see legal justification. I don't see logical justification, medical justification.
Right.
You might get canceled after me making these comments.
It's okay. The 50 people watching this, don't cancel us, please. So yeah, that's awesome. But so on that note, I think we're good. We had a great time talking to you. How can people get a hold of you and your firm if they wanted to talk to you about some cases as an employee, or do you guys take employer cases? Do you represent employers that get sued or have legal questions?
We do. We do.
Okay.
We don't, our brand is employee rights, but if an employer contacts us with a good case, then we will pursue it on their behalf. And oftentimes the employers do want to work with us because, we know the other side, right?
Yeah, you play both sides of the fence, so you know the arguments.
We're workers' rights, lawyers. So yes, so if any employers want to contact us, we definitely can represent them in court or help them with compliance issues, help them with audit issues. Ultimately, that helps employees, right? If they need to have an audit done to make sure that their job descriptions are accurate, that their exemptions are accurate, that, they're paying hourly or salary properly, employee handbooks drafted, et cetera. But really what we do 99.9% of the time is we're in court, we litigate, we're litigators.
Okay.
So, mostly on behalf of the employees, occasionally on behalf of the employers. Okay. And I didn't mention that, when during the pandemic, my partner and I also started a second law firm to focus on consumer bankruptcy.
Okay.
Given that we have vast experience working with individuals that find themselves, in trouble and kind of representing the underdog. We figured with all this money being pumped into the economy, there's just only a matter of time before it's going to crash. Once the stimulus money runs out, once, mortgage moratoriums. That
PPP money was manna from heaven. That was like, thank you, God.
So, so we also created a consumer bankruptcy law firm. And we're helping people get a fresh financial start.
So that's a separate brand, a separate company.
Separate company. Okay. Separate company.
Same amazing people.
Same ownership. Same ownership. But we do have a bankruptcy attorney, an amazing, fantastic powerhouse bankruptcy attorney who's working with us and handling those cases, and she's fantastic. So.
Cool. Yeah. Awesome. So the Hilton has not hired you since that verdict to do any work for them, right? No comment. That's attorney-client privilege. I'm sorry. So, all right. So how can people get a hold of your firm? And we'll put all the links and stuff up there if you want to check out there.
Okay.
Yeah.
So you can go... Microphone. My website, my firm's website is scienceanderson.com, or actually, let me give you a simpler link because... people don't always know how to spell it. miamiemploymentattorney.com, and that will take you to our website, Science and Anderson. And the bankruptcy law firm is called Financial Freedom Advocates. So you can go to financialfreedomadvocates.com, and you'll get all the contact information there, including our social media links. And we represent clients throughout South Florida and Central Florida.
Awesome. So we'll throw up all the links up on there. If you guys have any social media, we'll throw up your phone number, all that stuff. So one, I just wanted to say thank you for coming. It was really nice talking with you. We've been referring you cases for probably like 2 years now, I want to say. And
thank you. You've been amazing.
You guys have been amazing because we get calls and we don't know what to do with them. And we say, here you go. And you guys do a fantastic job. You guys speak English, Spanish, Russian.
English, Spanish, Russian, but we can accommodate clients who speak Creole, Portuguese.
Sac passe for the Creoles. We love them. Awesome. Well, thanks for coming on the show. And
thanks for having me.
Appreciate you.
It was a pleasure.
Thanks.